remains, then that can be covered, because we need not then.
Whatever timeline is given, they are our timelines, and it is always subject to your lordship's final call.
So after we complete with the first two arguments, we'll realize what canvas remains. Then I think.
But I just thought after you have taken and the attorney has taken 2-3 days, whether Mr. Banerjee will require 1 day to argue for what would be.
He didn't say 1 day.
Oh, he says 1 day. That's why we were
1 day. Therefore, I was.
No,
1 day, 1 day.
On part of my colleague. No, I'm sorry. It's a mistake on part of my colleague.
So Nataraj is 1 hour and he is 1 day. So I was wondering.
No. That is also 1 hour, but
all right.
That is outer. Now kindly correct it, Manoj. That's a mistake on our part.
All right. Yes, Mr.
Maybe as we travel along, the days can become hours.
I'm sorry, Manoj, your lordships.
We broadly know, I'm sure after you people have finished, they will see whether they want to add something or not.
Before I begin reading my brief summary of
summary of letter submission.
Lordships could locate. It's in the written submissions folder. It is titled Summary of Written Submissions. Just a 2-page document. But before I do that, I must certainly thank all my esteemed colleagues on the petitioner who brought in a lot of very insightful understanding of this emotion, passion-ridden issue and complicated from many angles. And we tried to bring our own, if possible, keeping in mind the objectivity as well as the neutrality which is to be involved in understanding this. And some American historian said objectivity is not neutrality. Therefore, sometimes these things can become problematic. So, keeping in mind, and I am also reminded of a very famous statement made by Abraham Lincoln in 1864 in response to a border territories conflict issue. He talked about balancing the nation, losing the nation, and preserving the Constitution. And he said, by general law, life and limb must be protected. But yet often a limb must be amputated to save a life, but a life is never wisely given to save a limb. I'll place that very full extract of it later on. For balancing between losing the nation and preserving the Constitution. Which will be my running theme in trying to say, if you want to say that Constitution will be preserved in the context of the processes, due processes, the fairness of the processes, and how these procedures are important for the integrity of the Constitution on the one hand, and losing the nation on the other hand.
Equally, Mr. Attorney General, we can't postulate a situation where the ends justify the means also, right?
I know about that, but
means has to also be consistent with the ends.
We all of us understand that. So very often this question confronts all of us, both in personal life, public life, the politics of the nation, the dynamics of the political process, and so on. But then that is a question which definitely confronts. So how do you find answers which will probably produce the most sensible solutions? So let me try to read this summary. No factual or legal foundation. Your Lordship, please.
Is that what you're reading? Or
The
summary of written
summary.
Copies. Yeah. Copies. This side. It is there. You mailed it. Lordships do not have it. Can I hand over a Roger Call has got that page. Well, may I proceed to read?
Yes.
No factual or legal foundation for any sovereignty argument. On a combined reading of the instrument of accession and the proclamation, followed by adoption of Article 370, all trace of sovereignty, if any, were surrendered and disappeared. The constitutional integration process of the state of Jammu and Kashmir with the Union of India, howsoever sought to be brought about, were the only object of Article 370. All principles and procedures pressed into service for the above purpose will always be considered subservient to this purpose. The power and deliberation authority of the President under Article 370 to deal with it in any manner is neither lost nor removed by reason of its exercise over a period of time, nor it can be said that the provision erased itself without intervention by any positive lawmaking power. Article 370 was conceived and designed to aid the constitutional integration process on the same line as it happened with other states. Its continued exercise over a period cannot be seen as a cloud over or a distortion of its original purpose. Any discretion exercised beyond its original purpose, seen as introducing room for whittling the constitutional integration or otherwise, can always be deliberated upon to bring about any changes in its contents or its abrogation. All judicial pronouncements in regard to Article 370 must be seen in the context of the challenges and claims placed before the court and their total view to be kaleidoscopically seen. Border states are a special class of territories of India, and their reorganization in Article 3 will deserve distinct consideration. The court will defer to the wisdom of Parliament in the choices of action relating to border states. The justiciability of decisions taken to deal with matters relating to border states may not be, as in the case of general run of reorganization of states or imposition of President's rule. The scheme and architecture of Article 356, which provides in regard to the sustenance of the fabric of the nation, will not be narrowed or compressed. The in terrorem argument demanding course correction or linearly tailored and need not be touchstone for ex ante tinkering in the undefinable state necessity potential of Part 18 of the Constitution. All instruments in aid of discharge of duty under Article 355, including the preamble to the Constitution, will be comprehended in the plenary power of Parliament to engage in the reorganization scheme under Article 3. The plenary power to act under Article 3 is available even during rule under Article 356. Long-standing or similar measures in regard to reorganization are not precluded. The availability of power is distinct from any due process. A. Neither asymmetrical federalism nor any other federal features have been infringed. We'll try to make good all these arguments. No rights in relation to representative democracy have been taken. Reorganization of states includes temporary or other rearrangement of rights to serve the integrity of federalism and the unity and integrity of the country. All rights are available for exercise only if unity and integrity are intact. The doctrine of necessity is flexible. The long history of internal disturbance, lack of availability of real measure of rights and justice are matters that can be legitimately taken into account for paving the path for due course rearrangements. No person can have a vested right in favor of a perennial state of unrest, and all instruments of law which have not subserved peace and justice have no inherent justice right to continue to exist, to right to exist or to continue. However, it is submitted that all measures taken are within the due processes granted and to be pressed into service to act in exceptional circumstances. All steps taken under so and so or within the standard set of provision issued during President's rule and nothing arbitrarily designed has been provided for. All arguments and fraud and power are therefore misconceived. That's a broad summary of my submission. Just before the solicitor takes over, as part of the paragraph 7B, the last few sentences, so I looked into all the presidential proclamations, running into 120 of them, and particularly in regard to Jammu Kashmir. The suspension of provisions of Article 3, the two provisos, and various other provisions of the Constitution of India, or in terms of a convention that the presidential proclamation follows. So no deviation has taken place as far as this particular presidential proclamation is concerned. So suggest therefore either a fraud on the Constitution is completely misconceived. I'll try to make good arguments referring to the documents. So I just want to play this summary to show that the due process has been followed. There is no deviation from due process. All falls within the legitimate aims and objects of what the two orders sought to achieve. And the Reorganization Act also falls within them.
Thank you. Thank you very much, Mr. Attorney General. Yes, Mr. Sultan.
Great piece, Your Lordship. But as indicated by the petitioners, your lordships would be taking a historical decision, in more than one ways. But first, this is for the first time, after 75 years, that your lordships would be considering that the privileges with which the residents of Jammu and Kashmir have been deprived of till then, till date, have been conferred. And I make this submission good, that so far, Article 370 function as a detriment between the welfare scheme flowing from the center, the constitutional right flowing from the center, and the residents of Jammu and Kashmir. But second thing, but because of this confusion, whether it is temporary or permanent, there was a kind of a psychological duality which was in the minds of one particular region of our country, though since inception of the Constitution, it became part and parcel of inalienable and integral part of India, but there remained a psychological duality, whether induced or otherwise. That, my lord, your lordships would end. Judgment going either way, my lord, that position would end. And third, my lords,
Mr. Solicitor, the first one, can you just in a sentence again formulate it? I somehow missed the first one.
yes. Lord, your lordships would find at the end
I
of
don't want to interrupt my learned friend, Bharat, but the new volume has been added. 2 new volumes have been added, which were not there before, 2 days ago. I don't know, Bharat. I may be wrong. I have no objection, Bharat, but I just want to point that out.
It was added with the permission of the court before 6 days.
It was added, that's all I'm saying, Bharat. The written submissions are new. I'll not object to any of that because I don't believe in objecting to materials which are relevant for the court.
No,
But since the court told me,
permitted. We mentioned your lordship.
I'm not disputing, you may have mentioned. I'm just saying, Bharat. I have still no objection, Bharat.
Volume 3 are your submissions, Mr. Solicitor?
What, your lordship, my lord, the Chief Justice would recall, Lord, what we have done is my submission, the submissions of the learned attorney, and my lord, all our submissions are placed in one volume. Our submissions, my lord, were new and detailed after, my lord, hearing them. And thereafter, my lord, in a chronological order and with continuing pagination, they form part of volume number.
On Monday, when the solicitor mentioned in the morning, you informed us that the list of dates which has been filed by Mr. Sibal,
Yes, that is incorporated.
you're adopting the same list of dates, but where you're adding something,
Yes.
you're putting it all together, so we don't have to flip between list of dates.
Written submissions are all new here.
Lord, this
Are
could have
all
been
new.
objected
I'm
on
not
that day,
disputing. I
Lord.
still am not disputing.
I believe.
I
Lord,
still
that-
will not dispute, and I'm just saying, Millet.
Then let's start, my lord, because.
I'm only
otherwise-
saying, Millet, I was not allowed, that's all, these are all new, but I don't mind, Millet, we'll answer.
What we had, when he mentioned on Monday morning, I think we asked him whether your notice has been given to everybody, and solicitor said yes. At that stage, I told the solicitor, instead of having 5 different list of dates, work on the list of dates which Mr. Sibal has submitted. I'd also mentioned it in the course of the hearing.
That's right, sir.
And in that list of dates, add what you are adding separately, so that we know what has been the addition by the Union of India.
Not only that,
All of us have one master list of dates, that becomes much easier.
I don't know.
it would have been better if this objection would have been raised, because we. Let's not,
Sorry.
my lord,
When
people are watching, let's not be, my lord, school children like objections, my lord. It was given on that very day at night,
No, it's because the
not
court
right.
Apart from that,
Not
please
informed.
hold your tongue.
Document is created on 24th August, which is today. The PDF says it's created 24 August. So I don't know how it could have been mentioned.
Mr. Prasanna, please.
Anyway, Millet, I think we should go on with the hearing, I'm not objecting.
No, let's say.
You object and thereafter you are saying I am not. objecting.
Because I was told that I should not be able to add anything, I had only put some, it is 5
No, no,
pages.
whatever is,
Mr. Bal,
Assuming that
your submission also, it would have resulted in many more people.
That's why, Millet, I didn't press it.
I don't think we should go on this.
But even that has been taken note of.
That's all I'm saying.
Mr. Gopal Shankar Narayan was here from day one. He could have told us, but my lord, I must make a positive statement. Before we mention before your lordships, the previous night, this was placed on record with a service to all. They were aware, and my lord, they knew that this is the master list of dates which all of us on this side will rely upon.
Your
But
Lordship,
Mr.
may I clarify?
One second. Mr. Solicitor, on your master list of dates, I hope you have maintained the integrity of the original list of dates.
Yes.
Where you want to add something that you have indicated to us in a separate note or separate color or track change.
What I have done is, my lord, I believe at the outset that it seems my list of date contains something, because this first objection appears to be the best point now, after, my lord,
leave
this
it.
list of dates. But leave it at.
No,
that. My lord,
Mr. Solicitor, the reason why we ask you is, when one sits down to dictate the judgment, I hope in the list of dates, we will know what is Mr. Sibal's part and what is your part. So long as that is there, it's no difficulty for us.
Come to page 1 of my list of dates.
So long as it is there, we accept your word for it, but so long as your juniors have prepared it in that way, there's no difficulty.
Mr. Sib, only a minute. Mr. Sibal's submission are incorporated in that general common list of dates in italics in blue color, saying KS, means
All right.
that's the list of dates of Mr. Sibal.
And whatever you wanted to add, you've added in a separate font or whatever, then there's no difficulty.
Nobody has any issue with the list of dates, it's just that they are filing something, they should tell everybody. What has been done today is there are 107-page list of dates which is filed.
Mr. Prasanna knows
But-
everything
Mr.
was
Prasanna-
served. You see, then this is what a nodal council is
Yes,
supposed to do.
yes.
So, one
I'm,
second.
I'm,
Please a moment. The learned solicitor's written submission, apart from the list of dates, has somehow ballooned from 18 pages to 139 pages of, and a lot of it in very fine print. Now, I mean.
I'll
this is-
put it the para.
Airdrop 3 minutes ago, 5 minutes ago, I got it on airdrop.
Huh?
So that.
But from
I mean,
Mr. Prasanna, not by me.
If you're, nobody, when Mr. Sibal says he has no objection, yes, there's.
But from your nodal council, he
Or-
gave you date, my lord.
yes, may I clarify?
We can.
Mr. Prasanna is trying to say something for last 5 minutes.
Yeah, Mr. Prasanna,
Yes,
My
we
lord.
were.
just 1 second, let's have a word from the young junior
It
here.
was certainly served last week, Your Lordship. I had not been informed that it had been allowed by the court, which is why I could not circulate it forward. So that was.
So
It was uploaded on Sunday night. Your lordships can check up now, everything, my lord, is possible to be ascertained and verified.
So say that it was emailed to him on Sunday night with a copy to Mr. Prasanna.
Yes, my lord.
Yes, that's correct. That's
In fact,
correct.
we should-
It was
I
not
don't want to
circulated
find
because it
fault
had
with
not
it.
been
We
allowed
should
by the
say
court.
that
That is
this
not
has
something
come.
that I had been informed that it had been allowed by the court. That was where the case is.
My lord, my first point, my lord, why your lordship's, my lord, judgment is going to be a historical judgment is this. A, my lord, after going through, my lord, the facts which we will point out on this side, your lordships would be satisfied that large number of fundamental rights and other rights will be now conferred upon the residents of Jammu and Kashmir. And they would be fully at par with rest of their brothers and sisters of this country.
Yes.
But number two, but because of, I'm sorry,
Yes.
because of the ongoing confusion, which according to us, there was none. But because of the ongoing confusion, whether this provision is temporary or it has become permanent, etc., there was a psychological duality amongst the minds of the residents of Jammu and Kashmir. And that was being taken disadvantage of by, I would say, my lord, interests not inimical to India. That would be settled once and for all, whichever way your lordship decides.
Yes.
Now, my lord, I'll take your lordship, my lord. I must, my lord, assure your lordship that yesterday we undertook an exercise that your lordships have been appraised with almost everything, my lord, on facts. But your lordships are specifically not appraised with many things. So, my lord, in my list of dates also, we have, my lord, marked which portions we would not trouble your lordships by reading. So kindly directly come to, my lord, in that common compilation, page 6, PDF page 6. So this is only for one reason, my lord, I am reading this part. My Lord Justice Gawai was pleased to put a question. There was a Praja Sabha constituted, your lordship would recall. And my lord's question was, what was the composition of the Praja Sabha? Well, that is what is mentioned. Your lordship would find the second date, my lord, on this page is 20.
Just only one thing, Mr. Agarwal, Mr. Kanu Agarwal. I'm not asking the solicitor this. In the list of dates, there is some dates which are marked by the light brown,
Yes.
one by green, one by blue, and
Please come
yeah.
to page
so
4.
is there a distinction for our
Please come
purpose
to
between
page
is there a like green, blue?
It's a legend. Page 4. Page 4 will be the answer.
We just want to see
Page 4.
when we have clarity, you know.
This is one of the color scheme which we have used.
All
History
right.
of Kashmir is this color.
All right.
Then British events, law and statements.
Agree.
Then blue will be Indian constitutional history. Red with the process of integration, etc. This is the relevance of the color.
All right.
But your lordships need not, my lord, bother about that. My lord. Once
All right.
the flow I have kept chronologically. So therefore, colors might keep on changing depending upon the legend, but the flow will continue.
And where you say KS in italics, that is Mr. Sibal's original. Fair enough. Got it.
Sibal's submission. Therefore, your lordships may consider not keeping Mr. Sibbal's submission side by side. It contains everything verbatim.
It's much easier.
As my lord produced before your lordships. That's all I wanted to show. Date 20th of April 1927. I'm not reading it, but this is Mr. Sibbal's submission in his list of dates, and I have not missed, my lord, any date from his submission. It is in blue color and in italics. The next date is 22nd April 34. Maharaja Hari Singh enacted 1934 Constitution of Jammu and Kashmir. This law established a legislative assembly called Praja Sabha, which was to function under the supremacy of the Maharaja. Lord, answering my Lord Justice Gawai's question, the Praja Sabha was to have 75 members, of which 12 would be officials, 33 elected members, and 30 nominated members. Then, my Lord, rest your Lordships can consider skipping, my Lord, and kindly come to, my Lord, 7. Just, my Lord, taking your Lordships chronologically, your Lordships have seen this provision as well. I'm just, my Lord, refreshing your Lordship's memory without reading the provision. Lord, this is a part of Government of India Act 1935. Lord, why it has become long, the relevant parts are quoted for your Lordship's immediate reference. My Lords may not have to go through volume 1, PDF page, so and so, but page numbers are also mentioned, my Lord, if your Lordship would like to go through. But please see, my Lord, at page 8, section 6 of Government of India Act 1935. Accession of Indian states. A state shall be deemed to have acceded to the Federation if His Majesty has signified his acceptance of an instrument of accession executed by the ruler thereof, whereby the ruler for himself, his heirs and successors, Lord, declares so and so, so and so, so and so. Lord, the purpose of showing this is to, my Lord, point out to your Lordships, and ultimately I'll assist your Lordship with that proposition and 1 or 2 judgments on this. The moment the accession is complete, the sovereignty gets lost. The sovereignty is subsumed with the bigger sovereign.
Yes, sir.
There is a Privy Council judgment and few other judgments also, Lord, which we'll, Lord, take a little later on. There is one trivia, my Lord, I have just added it. It doesn't make any difference for either of us. But as, my Lord, we attribute the Indian Penal Code to Lord Macaulay, Lord, this entire exercise of 1935 Act was done, my Lord. He was the author virtually of this, my Lord, Sir Samuel Hoare. One of the unsung heroes, my Lord, in the history of Indian partition, but it was he who drafted this. It has no bearing on the main question. Then, my Lord, I have reproduced the...
Actually, Mr. Solicitor, you may also read section 5.
Yes.
Because what is the importance of accession? That section 5(1) gives us.
Yes, my Lord, I wanted to read,
Just
but I thought your Lordships may have read.
No, we've
kindly
seen,
come
but
to,
we
my
need
Lord,
to highlight
section
that,
5,
because
PDF page 7.
it shall be lawful. They just read that, only that.
It shall be lawful for His Majesty, if an address in that behalf has been presented to him by each House of Parliament, and if the condition hereinafter mentioned is satisfied, to declare by proclamation that as from the date therein appointed there shall be united in a federation under the crown by the name of the Federation of India. A, the provinces hereinafter called governors' provinces, which were under the direct British sovereignty or suzerainty, my Lord, as the case may be, were functioning through the Governor General. Then B, the Indian states which have acceded or may thereafter accede to the Federation, and in the Federation so established, there shall be included the provinces hereinafter called Chief Commissioners' provinces, not the smaller regions, which eventually...
The consequence of an accession under the Government of India Act was that then the acceding, they would be united in a federation.
In the federation.
The key words really in 5 are united in a federation.
In a federation. So, my Lord, that is the first stage of losing sovereignty. The moment you sign accession and it is accepted.
But you'll have to at some stage deal with the argument which they have urged that sovereignty itself has an external component and an internal component.
That,
External component was lost, internal sovereignty still remained. That's
that's the argument, my lord. We are conscious of that. And, my lord, I'll also bear in mind your lordship's very, very pertinent observation that ends may not justify the means. I'll also show to your lordships the means adopted strictly within the constitutional parameters and as per various judgments of your lordship. But that's, my lord, after, my lord, the factual chronology. Thereafter, your lordships, my lord, kindly come to page 9, 1939. But this is also crucial. The Indian National Congress's formal stance was that the princely state must join independent India on the same terms and with the same autonomy as the provinces of British India, and with their people granted responsible government. As a result, it attempted to insist on the incorporation of the princely states also into India in its negotiations with the British. So we were, as Lord, British India also, our leaders were already negotiating that princely states should also come at par with the provinces, British provinces, which were already under the suzerainty or sovereignty, as the case may be, of the British. Then, my lord, 7th September 1939, Jammu and Kashmir Constitution Act 1939 was issued by Raja Hari Singh. It established a council with a prime minister. My lord, why, my lord, I'm reading this, my lord, I'll just paraphrase this argument. My lord, why I say this? But substantial arguments, my lord, were made that there were no constitutions. Jammu and Kashmir had a special place in the geographical British India because that was the only part which had its own constitution in 39. But that is factually incorrect. There were 62 states which had their own constitutions. Whether they are named as constitution or any instrument of governance, internal governance. I'm just trying to show that the argument that Jammu and Kashmir had a special status from the beginning, which continued till date, is factually wrong. The foundation is wrong. And 286 states were in the process of framing that constitution during this period of late 40s, late 30s, 39 onwards. As a matter of fact, but eminent councils of the day, those days, were, my lord, engaged to help the princely states to draw their constitutions. I'm not going into that detail, that's not relevant, but one of the, my lord, when we researched this, Alladi Krishnaswamy Iyer, who was considered to be one of the top ranking councils, was engaged. His fees were not found to be, the problem was there at that time also. By one state called Rewa in present Uttar Pradesh. I'm sorry, Madhya Pradesh. And therefore, my lord, he was requested not to continue because it was found to be too exorbitant. My lord, please see, my lord, from where do I get this? My lord, PDF volume 16, document volume 16, I'm sorry, document volume 16, PDF page 574.
document volume.
Lord, this is a research paper by a very eminent professor of Yale. He has, my lord, done at 584 directly, my lord, because this is history. I may not, my lord, trouble your lordships beyond a point, but 584. The running page would be 10514. But as a matter of fact, some of them made their constitution and thereafter immediately signed the accession also. And I'll also show to your lordships from this chronology that the draft accession agreement was common to all. Everybody has signed the same draft. I'll come to that. Please, my lord, see the second line. However, at page 584, my lord Justice Khanna and my lord Justice.
Yes, I got.
Yes, my lord Justice Kaul has that. However, the inauguration of Shahpura Constitution did not prevent the prince from signing the next day the instrument of accession to the dominion of India in three areas of defense, external affairs, and communications, as many other princely states did at the same time. Lord, next para, kindly come, Lord, some fifth or sixth line from the top of the unnumbered second para, Manipur. Your lordship would find Manipur. Does your lordship get Manipur? Manipur in the northeast adopted a constitution which on 26th of July 1947 provided for fundamental rights and separation of powers and recognized the Maharaja as its constitutional head. Maharaja of Patna declared the setting up of a representative constitution making body on 24th October 1947. Just as at the moment when the first draft of Indian constitution was ready, that same month, M.R. Jaikar, until the previous May, a member of the Constituent Assembly advised Gwalior State Constitutional Reforms Committee not to depart in their proposed constitution from the model now in vogue, for instance, at Mysore. This pattern of general steps towards constitutions based on principle of representative government was repeated in numerous other princely states. These included Ond, Banswara, Bauni, Baria, Baroda, Barwani, Banaras, etc., my lord. The list goes on and on and on. I'm not reading it because the names are not relevant. And this is whole length and breadth of the country. They were making either having their constitution or making their constitution. My lord, why? I just, my lord, we were just, my lord, examining why these three subjects are kept, my lord, even by them to themselves, my lord, namely defense, communication, and, my lord, foreign affairs. The reason was, I'm sorry, but there is a small princely state. It can't have its own army. Communication means the British had laid postal services and Britishers have also laid railway lines. So that communication was crucial, and every state can't have their own communication system for intra-princely state communication. And foreign affairs, my lord, obviously, my lord, they would like the greater power, my lord, to control. That was, my lord, basically the idea. Thereafter, my lord, as I go on, your lordships would be satisfied that ultimately everything started getting subsumed, and there are discussions. Once Article 1 comes into force with first schedule, all states which became part of the first schedule, Lord, came to be governed by the Constitution of India, and the only sovereign which remained was we, the people of India. Now, kindly, my lord, come back to my I'm sorry, my lord, last line, last line. I'm so sorry, my lord. In that page 585, first para, last line. So far as we have traced, your lordship gets, my lord. It's somewhere, my lord, fifth line from the bottom of the first unnumbered para. So far, your lordship gets, my lord. So far, we have traced 62 states that framed their own constitution and 286 others that were involved in making constitutions for union of states, which shaped the new constitutional landscape. This fact has gone largely unnoticed in the study of India's constitutionalism. So, my lord, first, why I am pointing out the basic argument that Jammu and Kashmir was the only princely state having its constitution and therefore was getting a separate treatment is factually not well founded. My lord, now your lordship, my lord, kindly come to my Lord, kindly come to page 10. Lord, your Lordship, Lord, page 10 is the list of dates. Page 10 starts with Mr. Sibbal's note, my lord, which I have quoted verbatim. Then 12th May and 22nd May, the lordships may not, my lord, invest time in that. Kindly come the next date, 16th May, 1946. The cabinet mission planned by the Britishers issued a statement regarding its report. Under paragraph 15(1) and 4 of this statement, the cabinet mission plan recommended that Union of India, which should necessarily deal with defense, foreign affairs, and communication of princely states. They only recommended, my lord. In the note of my learned senior, my lord, it is differently mentioned that it was decided. They only recommended. Lord, thereafter, my lord, page 11. Just a few weeks before becoming the vice president of the interim government, Jawaharlal Nehru clearly stated that no princely state could prevail militarily against the army of independent India. This is, my lord, the first step for unification of the Federation of India, which eventually became Union of India. This is July 46. Then, my lord, 9th December 1946, Constituent Assembly of India was formed. But there is no dispute on this date. Lord, Jammu and Kashmir had 4 representatives, including late Sheikh Abdullah. But the relevant parties, when more and more princely states started acceding and accepting the Constitution of India, their representatives also kept on being added, and they started participating in framing of our Constitution. And, my lord, I will come to that, my lord, at an appropriate.
One clarification.
Yes, ma'am.
The 4 representatives of Jammu and Kashmir were there from the beginning or only in October?
No, my lord, not from the beginning. They came, my lord, subsequently.
49, I think they came.
Yeah, yes. 49, my lord.
49?
It comes, that date will come. June 1949. Yeah, yes, that date will also come. And I mean, my lord, at the outset, my lord, just flag it. It would come in the chronological order. All these states who eventually became part of the Union of India had their differently worded instruments of accession. Some of them have said that taxation would be within our domain only. But thereafter, my lord, as the legislative and the constitutional history progresses, this is how countries are formed. When, my lord, we have more than one federal units, and it's unlike American federalism where they entered into a contract to form the union. We didn't adopt, my lord, that model in a very wise, my lord, foresight of our forefathers. That they did not choose that option. They voluntarily started joining and participating in the process of constitution making. Then, my lord, January 1947, Nehru, in his capacity as the vice president of the interim government, which included both present-day India and Pakistan, clearly said that independent India would not accept the divine right of kings. So this is January 1947. The stand of India and the party which led the freedom struggle was, we will not accept divine right of kings. We are going for a democratic setup. And that stand remained consistent, as I'll point out. Then, 22nd January 1947, the Constituent Assembly of India adopted objective resolution. But my learned senior, my lord, read only one part, my lord, which is para 3. My lord, let me read para 3 and then rest of them. These were the broad, lord, kind of objection reasons based upon which the Constitution was to be framed. Para 3. Declared that princely states that had joined the Union of India, whether with their present boundaries or with such others as may be determined by the Constituent Assembly, and thereafter according to the law of the Constitution, shall possess and retain the status of autonomous units, together with residuary powers, and exercise all powers and functions of government and administration, save and accept such powers and functions as are vested in or assigned to the union. Lord, the interpretation given by the petitioner was that the autonomy was the foundational stone of the constitutional making. Lord, this autonomy will have to be understood from the subsequent paragraphs. States are still autonomous in case of Lord, list 2, schedule 7, etc. There are several provisions giving them an internal autonomy while being a part of the larger Union of India. Paragraph 4, this, according to me, should be read. Declared that all power and authority of the sovereign independent India, its constituent parts and organs of the government are derived from the people. The seeds of democracy born for the first time. That the sovereignty would vest in we, the people of India. Then 5, declared that there shall be guaranteed and secured to all the people of India justice, social, economic and political, equality of status. Kindly mark this, equality of status was the avowed goal while framing the constitution. One union or one segment of the Union of India cannot be deprived of the rights which are enjoyed by rest of the countrymen. Then 7, declared that there shall be maintained the integrity of the territory of the Republic and its sovereign rights on land, sea and air according to justice and law of civilized nations. And 8, declared that this ancient land attains its rightful and honored place in the world and makes it full willing so and so, so and so, so and so. Now, your Lordship, kindly see the next day, 25th January 47, the resolution for the establishment of the Union Powers Committee in the Constituent Assembly was passed. Lord, your Lordships can skip the next day, Lord, a statement by Clement Attlee, the then Prime Minister of Lord Britain. Then, my Lord, 17/4/1947, the first report of Union Power Committee was that is, my Lord, of the Constituent Assembly, was published widely, expanding the scope of phrases, defense, foreign affairs, communications, and powers necessary to raise the finances required. Further, the said committee further recommended in para 3 powers and subject which were inherent or implied or resultant from the express powers of the Union, that is judiciary, services, RBI, etc. It was also hoped that certain other subjects would be included in the Union list or that like insurance, planning, banking, patents, etc. Lord, this is the first report. Lord, the note of the petitioner, my Lord, which I have quoted, does not mention, my Lord, about this first report. They have directly gone to the second report. Therefore, my Lord, this has its relevance in the chronology. I have placed it. Lord, second, the date can be, my Lord, skipped. Nothing turns on that. Constituent Assembly resolution appointing Union Constitution Committee, etc. Lord, 3rd June is an important date. 3rd June 1947. The legislative representatives of the Indian National Congress, the Muslim League, and the Sikh community came to an agreement with Lord Mountbatten on what has come to be known as 3rd June Plan or Mountbatten Plan. This plan was the last plan for I'm sorry. My lord, all these facts, my lord, would be necessary as a process of connecting the dots for me to, my lord, persuade your lordships to reach a particular conclusion. Even otherwise, whichever way, my lord, your lordships would like to ultimately decide, these facts would be relevant, my lord. Therefore, my lord, I am placing only those facts which are relevant, my lord, to the issue. My lord, now Mountbatten plan comes. This is the only plan, my lord, for independent India, my lord, last plan. The British government proposed a plan announced on 3rd June. My lord, I'm sorry, my learned senior, Mr. Dwivedi points out that this resolution, which I say, my lord, objective, but was thereafter passed, framed and placed before the Constituent Assembly in 46, which was approved by the Constituent Assembly. And the preamble, my lord, draws inspiration from that one. The lordships have seen the words.
There was a lot of discussion also on that.
Yes, yes,
Objective resolution.
yes, my lord.
It was proposed by Pandit Jawaharlal Nehru.
On 13 December 46.
Uh,
46.
Dr. Ambedkar criticized a lot about that.
Yes.
He said that there are many things which are missing in what we have promised.
My lord, as a matter of fact, the first letter of Dr. Ambedkar, while introducing the draft constitution,
Oh.
makes a very interesting detail.
So his speech of 4th of December 1948.
Yes, yes, yes. My lord, when we go through the Constituent Assembly debates of India, my lord, we really feel as citizens that we were in safest of the hands. My lord, now this proposal contains, my lord, these principles. Principle of partition of British India was accepted by the British government. Then second, successor governments would be given dominion status, autonomy and sovereignty to both countries, that is India and Pakistan. Then third and fourth and fifth is relevant. Both can make their own constitution. And fifth, princely states were given the right to join either India or Pakistan. Princely states had no option to remain independent under this plan. It comes thereafter in 1947, but Lord Mountbatten advises the Crown of the Chamber of Princes that it's not viable for most of you. You can't survive as independent units. But in this plan, they could join either Pakistan or India, depending upon several factors, but mainly the factor of geographical proximity. For example, hypothetical example, Delhi can't join Pakistan because of the land route not being available, etc. Now, my lord, next date, 27 June, your lordships may, my lord, skip, June 47. After the announcement of June 3rd plan, Lord Mountbatten spent 4 days discussing the situation of Jammu and Kashmir with the Maharaja of Jammu and Kashmir and clearly explained that independence of Jammu and Kashmir was not a feasible option. Then Viceroy, 13th of June 47, Viceroy Mountbatten invited Nehru, Sardar Patel, Acharya Kriplani, Jinnah, Liaquat Ali Khan, and Sardar Abdul Nishtar and Sardar Baldev Singh to attend an informal meeting to discuss the problem of the states. Lord, I may not read the whole. The purpose was that you create one separate department which would deal with integration of states. That was, my lord, the States Department, and the first secretary was Mr. V.P. Menon. My lord, this function under Sardar Patel. V.P. Menon was the first secretary, and he has written 2 books, my lord, as your lordships were told, on a request from Sardar Patel that you document it. You are the first person, yours have the first-hand information, and he has written both the books without being judgmental or without giving his value judgment. He has narrated the facts as he witnessed. Most of the documents are also signed by him. Letters are also signed by him. He had taken part in several negotiations also with princely states. Then, my lord, your lordships can skip 15th June 1947, Congress Working Committee. My lord, the same continued that will not accept divine rights of princely states. We are going for democracy. And, my lord, they rejected specifically the concept of paramount. The Congress was dealing with this issue and negotiating with the Britishers and with, my lord, princely states. Then 17 June 47, Nehru wrote to Mountbatten stating that Kashmir was of first importance to India as a whole, and specifically as a great strategic importance of that frontier state. We were conscious, my lord, from that day. Then, my lord, 18th June, Mountbatten urged on the Maharaja and the then Prime Minister of Jammu and Kashmir, Sri Kak, not to make any declaration of independence. He also pressed them to take measures to ascertain the will of the people and to announce their intention to send representatives to one constituent assembly or the other, that is Pakistan or India. The State Department, he told them, were prepared to give an assurance that if Kashmir joined Pakistan, this would not be regarded as unfriendly by the government of India. The Maharaja allegedly replied to the same by stating that he would never accede to Pakistan, as they were setting up a theocratic state. Mountbatten pointed out the dangerous situation in which Kashmir would find itself if it did not have the support of one of the two dominions after 15th August. Well, this is by Narayani Basu and V.P. Menon's book. They have reproduced. We have Lord Narayani Basu was, I think, granddaughter of V.P. Menon, and a very seasoned bureaucrat, subject to correction. The second part is subject to correction. Then, my lord, the State Department is formed. That date, my lord, your lordships can consider speaking. Then 3rd July 47, Sardar Patel wrote to Hari Singh stating that interest of Kashmir lie in joining the Indian Union and its constituent assembly without any delay, and also say that its past history and tradition demands it, and all India looks up to you and expects you to take this decision. At this juncture, India was not contiguous whole, and princely states were scattered across the length and breadth of the territory of the country. Then 5th July 47, department as the State Department was a part of the Ministry of Home Affairs headed by Sri Sardar Patel, came into being, and Sardar Patel issued a statement as under. But please see, my lord, page, my lord, 16, your lordships can directly come to, and only the highlighted part, my lord, so that I am not, my lord, investing your lordships' time more. I have few words to say, my lord, your lordships. See, my lord, we have dealt with every princely state in a democratic manner, and everyone has voluntarily come, including Jammu and Kashmir, as I will show, my lord, further. I have a few words to say to the rulers of Indian states, amongst whom I am happy to count many as my personal friends. It is the lesson of history that it was owing to her political fragmented condition and our inability to make a united stand that India succumbed to successive waves of invaders. Our mutual conflicts and interns, quarrels and jealousies have in past been the cause of our downfall and our falling victims of foreign domination a number of times. We cannot afford to fall into those errors or traps again. We are on the threshold of independence. Then, my lord, again the highlighted part. But there can be no question that despite this separation, a fundamental homogeneous culture and sentiment reinforced by compulsive logic of mutual interest would continue to govern us. Much more would this be the case with the vast majority of states which, owing to their geographical contiguity and indissoluble ties, economic, cultural, and political, must continue to maintain relations of mutual friendship and cooperation with the rest of India. Lord, please, my lord, come to next page, my lord, 70, highlighted and bold part. But I am skipping something which is in the same breath, my lord, same line, Lord Sardar Patel says. Nor would it be a policy, but I am reading the highlighted part only, nor would it be my policy to conduct the relations of the new department with the states in any manner which severs of the domination of one over the other. If there would be any domination, it would be that of our mutual interest and welfare. Lord, this is where, my lord, Sardar Patel showed the seeds of, my lord, federalism and balance of powers, that nobody would be dominant, nobody would be subservient. The only thing dominant would be our mutual interest and unification and unity of the nation. Then, my lord, 5th July 47, the Union Powers Committee submitted its second report, my lord, which was placed by my learned senior, my lord, Mr. Sibal. Kindly, my lord, first was not placed, and I want to read fully, my lord, only a part was read, my lord, read, and it may have, my lord, potential to assist your lordships. Only a highlighted part, my lord. Or I may read, my lord, the full. Momentous changes have since occurred. Some parts of the country are seceding to form a separate state, and the plan put forward in the statement of 16th May, on the basis of which the committee was working, is in many essentials no longer operating. In particular, we are not now bound by the limitations on the scope of union powers. The first point accordingly that we considered was whether in the changed circumstances, the scope of these powers should be widened. We had no difficulty in coming to a conclusion on this point. The severe limitation on the scope of central authority in the cabinet missions plan was a compromise accepted by the assembly, much, we think, against its judgment of the administrative needs of the country in order to accommodate the Muslim League. Now that partition is a settled fact, we are unanimously of the view that it would be injurious to the interest of the country to provide for a weak central authority which would be incapable of ensuring peace, of coordinating vital matters of common concern, and speaking effectively for the whole country in the international sphere. At the same time, we are quite clear in our minds that there are many matters in which authority must lie solely with the units. Lord, stronger center, but federal structure. Lord, therefore, we say it's more unitary than federal, or more federal than unitary. Lord, that is the first route. Units, and that to frame a constitution on the basis of a unitary state would be a retrograde step, both politically and administratively. We have accordingly come to the conclusion, a conclusion which was also reached by the Union Constitution Committee, that soundest framework for our constitution is a federation with a strong center. In the matter of distributing powers between the center and the units, we think that most satisfactory arrangement is to draw 3 exhaustive lists on the lines followed in the Government of India Act 1935, that is federal, provincial, and concurrent. Lord, appendix to this report, my lord, please see the note. The appendix to this report had a union list with a wide array of subjects, that is 87 in total, my lord. Now we have 97, my lord. Now, my lord, kindly come to, my lord, the next date, 10th July 1947. So this is a very important statement made on the floor of British Parliament by Clement Attlee, he then Prime Minister of India. This is not available otherwise, but in one of the recent judgments of the British court, where, my lord, there was a dispute regarding properties of Hyderabad's Nizam. Lord, this is quoted. He had transferred some $1 million and there was some dispute between High Commission and Nizam. That's not relevant. From there, this